advice do you have to homeowners?
Practicing that preparedness, starting the conversation now is always going to be a benefit to any association out there.
And welcome to Recovery Report Live, GlobalPro's deep dive into relevant business and insurance topics, providing you actionable takeaways and valuable insights. We aim to update, educate, and inform you weekly. I'm Dan Odess, president of GlobalPro, where we manage risk to recovery. In last week's episode of the Recovery Report Live, we took a step back from claims and focused on mental health and women in business. We had a special guest on that coined the term mompreneurship. It was definitely a really interesting episode and learned a lot from him myself, and certainly working with my wife all the time, and as being a mompreneur as she is, it gave me a little better understanding of her needs and wants in life. So it was awesome to have her on and to talk about those things, and definitely encourage all of you to tune in and check it out. The week before that, though, we had our very own Josh Bachner on to discuss coverage for construction-related damages for community associations and an alternative to costly litigation, an option that many associations don't even realize that they have. So it was great to have him on to particularly focus on some case law. We want to continue that discussion today but a little bit later in the broadcast, and get into some of the details regarding the investigations and the claims process in which we handle it. So we built the foundation for why we can make these claims. Now we want to talk about how you go about it, what you need, what you shouldn't do, some pitfalls and some issues and how we at GlobalPro, and working with experts and contractors, can help you as a community association recover in the event that a nearby construction project damages your building. But before we go there, I have to address probably one of the most ridiculous articles I've read since the pandemic occurred. It's an article that I saw recently in Law 360, and in my humble opinion, I have to say it's probably one of the most anti-consumer pieces I have seen come out related to litigation and these issues regarding coverage for pandemic-related losses. I was actually scratching my head, and I honestly was at first loss of words, had a lot of thoughts running through my head, sat back, thought about it a little bit, started discussing a bit of the issues that were raised inside the article with some of my colleagues and employees, and we even had a bit of a little powwow with our team to talk about some of the issues that were being raised in there. And one of the things I just keep pointing to with regards to all of these pandemic-related losses is that I find it strikingly interesting and more concerning that new policies now have endorsements that specifically exclude COVID. Never before. So it begs the question that if my prior policy, for which maybe my insurance company denied the claim, or maybe they're delaying and claiming they're doing an investigation, was silent on the issue of COVID, and now through a renewal I have an actual exclusion, how is it the opinion of a lawyer that it is the litigators in the U.S. that are trying to influence and change the law through litigation, when it's the insurance companies that seemingly, I don't know, maybe forgot that they had access to these forms and just didn't include them, but now they're taking the position that the prior policies didn't cover for these losses, even though it was silent or devoid of those forms, when at all times they had access to those same forms. These aren't new forms. So I just find it strange that it's the litigators that are the problem, and that was the opinion in the article, but somehow the insurance companies, who are now only for the first time including these forms, are not the problem. I mean, let's be honest here. Is it the insured that bought the policy protecting their business from a loss? Are they the problem? Or is it the insurance companies who didn't include endorsements excluding viruses or bacteria that are not covering the claims? I mean, let's be honest. If they intended to exclude viruses and bacteria, why didn't they just simply endorse the policy to exclude for it? Also, the distinction between loss or damage. The policy provides both loss or damage, conjoined with the word use of or, right? They used the word or. The insurance companies decided on the word or, not and. So clearly there must be a distinction between the idea of what a loss is versus damage, right? So direct physical loss or damage, right? Loss, income loss, loss of use, all kinds of different types of losses you may have. And then, yes, you have damage, a broken wall or a contaminated property. There's other types of physical damage as well. And it goes a long way to explaining why there are so many policyholders up in arms, hiring lawyers and suing their insurance companies because their claims have been denied. And so when I read an article like the one I saw this past week, talk about litigators being the problem and trying to change the laws through mountains of lawsuits being filed, I have to take a step back and look at things a little bit differently for obvious reasons, right? The facts are these policies were silent on this issue. They did not include these exclusionary language that the insurance companies are trying to insinuate somehow existed or created a basis for them not to cover these losses. And it's infuriating because we represent so many business owners that don't have policies with exclusions in them for viruses or bacteria. Certainly, I haven't seen a policy anywhere, even those that include certain said endorsements with the words virus or bacteria in them, they certainly don't mention the word pandemic, which is certainly different than, let's say, damage from virus. Okay, a pandemic is much more all-encompassing. It has much more moving parts to it. That's why this isn't an epidemic. This is a pandemic. This isn't just a viral outbreak. This is a pandemic. Even our president in the United States created a distinction between that of a virus and a pandemic, right? Early on, they said that. And I also find it interesting in this article where they said that these policies never intended to cover for it, when I just read an article yesterday where certain insurance companies are reporting billions of dollars in potential claim payments, and they've already paid tens of millions of dollars or have spent tens of millions of dollars in dealing with claims as well as paying claims. So they're spending money investigating claims, they're paying claims, yet they're generally not covered. Certainly not true, right? And that's what this is about, and that's what this show is about, is making sure that our clientele and those that are tuning in have the information they can use to help them as policyholders. We're paying more for far more inferior products. And so, and I think it's just, it's interesting to me how we're this late in the game and we're still seeing this spin game, right? Trying to create a scenario where the policyholder is the cause of the problem, right? Through their lawyers, they're bringing all these mountains of lawsuits, and that's going to drive up premium costs. Premiums were already going up, newsflash. We saw premium increases December last year, January, February, March. It didn't slow down. Don't blame the pandemic for rising rates if you weren't even sure or had yet to even quantify the impact or damages caused by that pandemic. That's not, again, not true and not factual information. Now, certainly in the future, as we see things go and evolve, and as these insurance companies pay out the billions of dollars that they expect in claims, obviously there's going to be a market impact to that. But the reality that it's because of the litigators or because the policyholders bringing these claims and everything else is a direct result of all these different things, or that it's useless, or that they're trying to change the laws and whatever else. It's kind of like, you know what, you had access to these forms, you didn't include it. There's distinctions in these policies between loss or damage. There's all kinds of other interesting nuances to these policies that the insurance industry doesn't want you to understand or know about. So it's important that all of you have the information that you need in order to be able to do what you need to protect your interests in these claims. And so I think, it's a great opportunity and a perfect segue into our next portion of this episode of Recovery Report Live, where I'm going to bring on Mr. Bill Pyznar of Falcon Engineering, as well as Mr. Craig Applebaum, our very own Senior Vice President, to talk about another issue that we're seeing, a rising issue that we've seen over the last number of years, something that GlobalPro has been on the front lines helping a lot of community associations. Welcome, gentlemen. It's good to see both your faces.
Hey, Dan.
Awesome to have you guys on. Thank you for taking the time this morning, Bill. I know we're all very busy, and certainly the construction industry never slowed down, and I know that's a big practice area for Falcon Group and helping and supporting that industry and all the new developments. And that's really what today is about, is talking about the impacts. We want to talk about the impacts of nearby construction on existing properties or buildings, whether they're businesses or community associations, particularly for community associations, because I think they're the ones that struggle with it most. A lot of misinformation out there, kind of like the pandemic. That's why I think it's a great segue to talk about some of the misinformation we're still seeing come out from some talking heads. And again, in my humble opinion, obviously disagree with a lot of what's being said. And I think the same can be said with some of these construction-related damages. But before we talk about the actual claims themselves, what I'd like to actually talk about is how can we help our community associations better prepare in the event that a building is going to be built up next to them. With the increase in density in these urban core areas, we're seeing all kinds of interesting things, whether the buildings are coming down and new buildings going up. We're seeing multiple buildings being bought all at the same time, and then a larger project going in place of, let's say, multiple smaller projects with all kinds of setbacks. They're getting all kinds of variants of those things. As a licensed general contractor, having developed properties, I'm all about progress and redevelopment and things like that. I think it's a great thing. I love what it does for our economy, what it does for jobs and all those great things. But I'm a community association. I hear about a permit being pulled for a project next door. I'm getting ready. What am I doing, Craig? What am I doing as a board? What are my rights?
Well, as a community association, when you have a building, a neighboring building that's either having significant work done to it, or maybe it's a brand new building and going up, there are a few things the association can do. One is certainly in dealing with code compliance and making sure that the neighboring building, is complying with regulatory codes when they're doing that construction to their building, because ultimately it is you, the building that isn't getting the work done to it, that has the risk of damage. And it's a significant risk, often in the 7 or 8 figures of damage from neighboring buildings. So one of the things you can definitely do is code compliance, work with code compliance, work with the city, and encourage a relationship with the neighboring developer to do the same, and to work only during certain hours, to monitor the sort of pile driving activities that are happening. That's another common damage for associations, where you have a neighboring building driving piles, and then you have the vibrations coming through, and it's because they're not doing it in the proper way, where they should be having it the vibrations at a certain level, and they're actually exceeding that level. And sometimes that can be another issue that we see out there. So certainly reaching out to the developer, neighboring building, and the contractors, and getting the city involved as well concerning code compliance.
Yeah, we'll definitely get into some of the damages and issues that we're looking for, and some of the ways we deal, like with regards to the vibrations. Definitely all good points. But Craig, I want to stay on you for a second and talk a little bit about good neighbor agreements, right, as they've been coined.
Sure.
I hear that word good neighbor, or let me say term good neighbor, thrown around quite a bit amongst your fellow colleagues that are lawyers. And I find nothing good about them, these agreements. What are some of the things that you're seeing that attorneys are recommending these associations engage in these neighbors? Why, and what are the pitfalls of these types of agreements?
So good neighbor agreements are a little misleading, because I think that the name implies that let me go back and explain. A good neighbor agreement is generally when the building doing construction approaches the neighboring building and says, hey, in the event that there's damage, we'll take care of that damage for you and help restore the property. Generally speaking, they will offer either to actually do the service, or offer an amount of money up front, saying, for $250,000, this absolves us of all of our liability. If any damage that we could do, you get it up front. And whether or not there's damage, here's the money. And sometimes that can seem like a great proposal to an association because they're thinking, oh, how much damage could there possibly be? The answer to that is tens of millions of dollars. There could possibly be tens of millions of dollars in damages, and even in claims where, in cases where GlobalPro has come in, where an association has been offered a few $100,000 up front and rejected that and ended up making claim and recovering millions of dollars. And had the association accepted that good neighbor agreement, it would have cost them roughly $3 million to do that. So I think you need to be very careful. An association needs to be careful concerning good neighbor agreements. However, there are some things that you can do with a good neighbor agreement, such as get money to provide access. Sometimes you have some land that they want to be able to use in order to move some things around, and in exchange, not for liability, but just for use, purely for use, they'll pay you, or to maybe be able to work an extra hour a day and not have you get the city involved with compliance. They'll pay you something extra. And that is something that can be very attractive for an association, but you want to make sure that you don't hamstring yourself for any damages to the building as a result.
Yeah, and I like to say is like, why give someone a license to damage you? I mean, let's hold them responsible and accountable for what it is. And I think that you make a lot of good points regarding access and some reasons why you would want to be or you want to engage the new developer or contractors in some type of agreement with regards to those things. But damage to your property is certainly you don't want to give up. And I think another good point, something we talk about a lot, is that some of these good neighbor agreements may actually, in fact, prejudice your own insurance companies if in the event that you do experience damage. So you got to be really careful and make sure that you fully understand its implications. Bill, I want to transition over to you and talk to you a little bit about, I know you've been engaged at times by associations before these projects nearby go into the ground or go up, whatever you want to say it. What are some of the things as an engineer that you're looking for to document as far as the condition of the property? Because it is a good practice and procedure to get someone out there early on to make sure that you document what your building looked like before they start construction, right? So what are you as an engineer looking to document at the property?
Yeah, well, it's really important. Ideally, in a perfect world, we get out there prior, like you're saying. And it's really, and then it's a four-pronged process. First, we want to review the plans for the new building that's going up. We want to understand, what kind of foundation is it? Are they driving piles? Are they putting helical piles in? Are they excavating? Are they doing a deep excavation? Are they dewatering? What is the proximity of all that work to our building, our subject building, our client's building? We want to understand our client's building. We want to look at the plans. What type of building is it? How flexible is it? How tall is it? How deep is their foundation? What kind? And so we can start to understand before we really go look at the building is how is this new construction theoretically potentially going to affect our building? Second thing we want to do is survey the building. Obviously, we want to do a pre-construction survey. Ideally, I like to fly a drone around the building so we have video documentation of the whole existing building. We want to get into units where we can look at balconies and doors, perhaps survey the property owners just so we have a record of, hey, I don't have any issues with my building, or here's some things that pre-exist so that we can sort those things out later. We want to inspect the structure to the extent that we can. So you want to get into the parking garage, the foundation system, look for any kind of cracks, settlement, failures of PT cables, things like that. We want to take a lot of photos, obviously, of any existing conditions. There might be cracks. It might be an older building, but what is the existing, what is the width, what are the locations of those cracks prior to the construction, so that if the event happens where those cracks are that they increase, or there's other locations, we have a clear definition as to what was caused by the new construction and what was not. The third thing after surveying and documenting the existing condition of the building is monitoring the construction. Depending again on the type of building that we have for our client and the type of construction that's going on, we might want to put inclinometers on there. We might want to put seismographs. We do a lot of this in the northeastern states of, like in Jersey City, in New York City, where there's, very little land and buildings are basically right on top of each other. In fact, in New York City, it's a requirement by the DOB that there has to be a pre-construction survey and on-site monitoring of adjacent buildings when you have that type of construction.
It's funny you say that because I talk to people about that all the time as I grew up in the Northeast, and it's remarkable to me that the care and consideration by contractors, developers, as well as the state and local authorities to protect neighboring buildings, and I feel like there's a lack of that obviously here in South Florida, or maybe Florida as a whole. So we're seeing this kind of rise. You took us through a little bit about the process, some of the things that you're looking for. Really, obviously, really interesting, and certainly can be impactful and helpful to an association. And I'll let for an association, unfortunately, a lot of things are based on cost, and time. How long does it take? What do you typically expect on the expense side to do something like this? Because again, we get the question all the time from our associations. Bill, for Falcon, what do where do you expect that cost, and what's the timing? I mean, from the time of retention to the time of your report, how long does it typically take you guys to do that stuff?
Well, if it's new construction and you want to do a pre-construction survey and monitoring, we merely have to go through and look at the plans of both buildings and what the effect is. I mean, I don't want to put monitoring equipment all over a client's building just for the sake of having it when they're putting helical piles and they're not doing a deep excavation.
Sure.
And I have seismographs and inclinometers and automatic notification apps and things like this hitting us up. So I really need to understand it before I could do that information. I could do that. And then how long is the construction process? If we're going to do like we do up in the Northeast and we do full construction monitoring, is it a 3-year process? And what is the time requirements? Probably heavy in the building in the beginning when we're putting foundations in, and then, more periodic when they're doing, when they're coming up with the floors and, looking at things like the concrete overspray and things like that. So it's really a function of the type of building, the duration of the project and whatnot. When we're doing, after the fact, building, they didn't hire us pre-construction, building's up and they say, oh my gosh, we have damages. And that's typically a 2-month process. Obviously a little bit different. We're going in, we're putting together the puzzles to the pieces, trying to figure out, okay, well, there's concrete overspray, but did the association do a balcony reconstruction project, 2 months prior to? So we need to understand the materials that were used, and it's kind of more document review and interviews with the maintenance staff managers and residents in that case. A little bit of a different process. In the latter, it's probably a 2-month process if we can get the documents and get the inspection scheduled.
No, I think that's really helpful because I think a lot of associations almost kind of sometimes wait to the last minute, and the materials are already on site next door, and it's like, had I been here before, might be able to talk, learn a little bit about it, and I find that sometimes for these contract developers, it's kind of like out of mind, out of sight. If it's not within the perimeter of their fence, at that point when they're ready to break ground, they don't even bother about these issues. So getting in there early and talking to them and collecting this information that you talked about, it does take time. So you have to make sure that you coordinate that accordingly and plan for it. And so for Greg, I want to talk a little bit about the expectation that nearby projects most often always cause some sort of damage. So want to go through some steps that an association can take to protect themselves from this damage, and like what kind of photographs, videos, or other things can an association obtain on their own behalf? Obviously, it's nice to have Falcon Engineering and Bill and his team out there to do those things. But as Bill mentioned, there's different types of services, right? There's that like all-encompassing, we're there all the time and everything else. Maybe it'd be something that an association, quite frankly, can afford. But doesn't mean that you shouldn't do something, but there's a lot that you may be able to do on your own. So take us through some of that, Craig. What can an association do to help prevent and protect themselves with the start of a new project?
So in the start of a new project, you want to be able to document the condition of the property before the neighboring project actually starts. So that's going to be very important as your baseline to be able to show in any, whether that's a claim or that's a lawsuit, you're going to want to show the condition of the property before the construction starts. Because then, as I said, you'll have this baseline and you'll want to document damages as they occur. So it's also important to, as there's most commonly you may see some overspray from the stucco that comes on your building. You want to document that. You want to be documenting any we've seen due to the vibrations, cracks in lobby floors. You want to document those as they go on. You also want to show some sort of proactive approach to trying to get this resolved, communications with the contractors to let them know, provide notice, and preserve that notice. That will oftentimes be a very important part of any claim. Again, whether that's through the insurance companies or maybe in a lawsuit against the contractors, you want to have provided notice. And if you don't say anything to anyone for a number of years, and then you try to file a claim or you try to go after that contractor, it can be very hard to establish that those damages are from the construction. So certainly documentation of that and of the notice, as well as the damages via, like you said, photographs, videos. I know that we've been on properties before where there's literally EFIS flying off and snowing on us almost. And that becomes a very powerful video because you see directly how that's affecting the property and damaging the property.
You talked about the different types of materials and things that are going on. Bill, a lot of questions I get from associations are about obtaining copies of plans and permits to find out what the stuff is. You know, they might see the stuff snowing down on them, but they have no idea what it is. And I've seen associations go through a whole lot of investigation to try and obtain it. Are those the things that are available to associations that they can obtain and collect about the project going on next door? Or how, if not, how do they go about getting it?
Yeah, they should be able to obtain it from the building department. And ideally, if there's a big project that's being planned, and usually people probably don't have the foresight to go to the city meetings and you know, go sit through the meetings for approvals and understand what the project's about. But once a project's starting, you should be able to obtain a copy of those plans from the building department. I would assume that if you're not getting any success in that way, that your attorney should be able to write a letter and, you know, make a demand for them for, you know, citing the potential for defect. And
something as part of the types of construction, everything else, we get a lot of questions about piles. You've mentioned the word pile a dozen times at least in the beginning of the broadcast. So what is a pile? Because I get a lot of questions about it. I've been in construction. I've put them in the ground. You know, as an engineer, what is a pile? You know, I'd love for you to describe that for our, and you know, like you mentioned different types of piles. Why is one different than the other?
Yeah, so a pile is essentially a type of a deep foundation. And as it suggests, it's a pile. It's a slender column that goes down through the soil to support the loads of the heavy building above. There's basically two types of piles that are used, or general categories of piles. There's friction piles, which is the pile is compacted down into the soil. This is typically where you have softer soils and bedrock is too far or impractical to reach. So the building is supported as the pile is pushed through the softer soils. There's friction forces that are built up on the pile, and that's how the pile supports the building. And then there's end-bearing piles. And end-bearing piles, as they suggest, are buried down their end. They go right down to the hard surface of the bedrock below. And sometimes that bedrock might be 50 feet. Sometimes it might be 200 feet. And, you know, where it's 200 feet, they often find that, you know, there's a cost benefit analysis that has to be done as to what type of pile to use. And then within those categories, you've got screw piles and you've got driven piles. A screw pile has much less impact. As you can imagine, they're screwing it down into the earth. You don't have these vibrations that come from it. And then you have impact piles that, you know, you have And I'm sure anybody who lives anywhere near downtown Miami, you've seen this over the past decade where they're pounding and pounding and pounding all day long. And that vibrates the sound, and you're doing that hundreds of times throughout the site. So those are the basic two, the categories of piles. And then with that, not necessarily associated with the piles, but is the excavation adjacent to your building. How deep do they need to excavate? And what type of system do you have? Do you have piles? Do you have piles? How deep do they go down? Do you have spread footings? A lot of the buildings, like 11 stories tall in this area, built on the spread footings. You have a high water table. Do they have to de-water for their excavation? In which case, when you de-water, you're removing the water from the voids within the soil, and you have some potential for settlement. In fact, there was a claim, probably one of the largest construction claims recently in the U.S. was in San Francisco, the Millennium Tower, which recently settled. It was a $200 million claim. I think they ended up coming up with $100 million solution, and 30% of that went to a transit center that was constructed after the Millennium Tower was put up, and they were responsible for about 30% or $30 million of the $100 million fix. And as resulting of dewatering next to these friction piles in the San Francisco Bay Area, we have the soft soils. And the building actually settled 18 inches and then started leaning 14 inches.
Can show an extreme situation, and I mean, we've had them here in Brickell, South Florida areas. I know when I was doing construction in Washington, D.C., we had an issue with one of the buildings. I was actually building for the contractor, where they started doing the drill piles and actually hit the footings of this historically protected building next door, and blew out all the pipes in the basement. So this stuff, even when you're trying to be soft and conservative with regards to the way in which you're putting those piles into the ground, and you're not there with the big diesel hammer smashing it in and doing a slow drill, you can cause a lot of damage. So it's definitely, and knowing what you actually have is actually a great point that you just made. But I think there's a lot of focus, a lot of associations on what is going in rather than what they have. And I think that's where a lot of problems occur, is that they're not looking close enough at what they have and how it's going to be impacted by what they're going to be putting next door. So, and I think this is a great conversation about that, and I think it'd be very helpful to like community associations and understanding the different types of piles, because we get a lot of questions about piles. It's a word thrown around a lot. And Craig, I know on the insurance side of stuff, a real simple question: is it excluded? If I'm damaged because of the pile work they're doing, is it excluded?
No, it is not excluded. Absolutely not, is what I would say. And we have been a part of many a recovery for those damages. And you show them the same way, and sort of what we were talking about, what I had alluded to at the beginning of the program concerning the vibrations. There's testing that you can do that shows the vibrations, what sort of vibrations will affect the building, and those measurements, if they exceed the levels they're supposed to be at, that cause damage, it's pretty compelling evidence.
Yeah, and one of the things, we talk a lot about association property, and we're talking about piles, which is a big issue. We just hear a lot about it. We've seen recoveries of millions and millions of dollars for damage caused by this type of construction. But I think one of the things that a lot of associations kind of shy away from or don't get involved enough in is the damage to unit owner property. A question and a concern of a lot of associations, but I do see a lot of managers shy away from the conversation and say, "Oh my God, that's not the association property. You're on your own." And Craig, you and I talk a lot of time about how it may create a problem, because the first thing that a contractor wants to do when the unit owner starts complaining directly to the contractor is come onto the property. In order for them to come onto the property, they now need association authority, and then to do work on the property. I've seen unit owners literally have the contractor start attempting to clean and do all sorts of things to association property as part of maintenance or their prescribed remedy for this damage. And then I see it, and then it just causes more damage to the property. I know, Bill, we saw a lot of that in for a Brickell Condominium Association that we were dealing with together. you had been retained by the association, and we were there working for them as well, making the claims, and there was a lot of concrete overspray. Bill, talk to me a little bit about how can unit owners remedy issues of concrete overspray to their personal property? Is there anything that you've seen that actually works? And are there other things that they may be able to consider for other types of damage, like dust or debris or anything else that may be damaging it?
Obviously, if you have personal property out on the balconies exposed, remove that, cover it, do something to protect it. Because we've seen a lot where you get that concrete overspray onto, high-end furniture that's out there. It etches or eats into the paint finishes. It gets, it bleeds into the fabrics. It gets damaged. I mean, obviously, you could do things like try to cover the windows if the case that, if you're responsible for your own windows and doors. But that's not always practical. You don't get ventilation. You don't always get daylight through there. So that's not too practical. People could try, I've seen people trying to wash their balconies on a regular basis because the amount of dust that gets on them. Again, not that practical. You're washing that debris down onto your neighbors. So it's relatively difficult. We've also seen a lot of homeowners where they try to, as you alluded to, remove some of those materials themselves, and they further damage the property. Because there's ways to do it. There's through trial and error. We've worked with a lot of restoration companies and whatnot, to try to remedy these things without having to do full replacements and whatnot. And it's a very careful balance of chemicals and processes that has to be done in order to attempt to do it properly.
Yeah, I like the word practical. You used it a couple times there, and I think that we've seen insurance companies take the position that the association should have been doing something to protect its property or mitigate its damages, and I think the word practical is a very, very good one, because quite frankly, sometimes the cost of that protection or whatever, I mean, maybe more than the replacement of whatever it is that's going to get damaged. And also too, I've had to explain to a number of unit owners that putting a pressure washer on a 30-story balcony is a bit different than being on the ground floor. How do you get the water up 30 floors? And most unit owners don't realize that the way the water gets into their property is through a bunch of sophisticated valves and systems to pump the water to that, so that they have the same advantage of and same amount of water pressure as those on every other floor. So there's a lot of technical information that goes into this stuff, and a lot of people don't appreciate it as much and don't consider the cost of doing that, like the pumps that would be needed. And then where does that water go, and how do you capture it? Because you can't just let it run off into the sewer, right? And you need to collect that water. It's got all kinds of chemicals and construction materials in it, and even if that isn't even a viable solution, because it may not be an issue of practicality, it may be an issue of it's just not fixing it. It may be even making the situation worse. So Craig, I mean, we get asked, and I know you've had this question quite a few, about are associations responsible for damage to unit owner property caused by nearby construction?
So the associations ultimately should not be bearing the responsibility to the damages to unit owner property. That liability should stay with the developer, the contractor. At the end of the day, it is the contractor developer that is causing this damage. And whether that's through insurance, because maybe some people don't understand this, but oftentimes, even if you file a first party claim, they're going to go subrogate and still end up going back after the contractor developer, because at the end of the day, they are the wrongdoer here. And they're the ones responsible for making people whole.
A great point. And I want to wrap it up on one last question for you, Craig and Bill, to talk about the differences between making those claims on the association's own policy, a first party claim, versus a third party claim, or making claims against a contractor. Because in your respective roles, either as a claims advocate for Craig or an engineer working for an association and helping them identify and maybe quantify their amount of their damages. How do the processes differ for you, Craig, in doing first party versus third party? and just quickly some advantages of either or.
Sure. So the difference ultimately is that there's significantly more cooperation coming from your first party from your own insurance company. Part of that is because the association is in privity. They have a contract with the insurance company, versus when they go after, if it's a third party claim, you're going after the contractor. They don't have a contract with that contractor. They don't have a contract with that contractor's insurance company. And therefore, you can run into problems with cooperation. Additionally, the way that the payments work as between replacement cost value, which is something that you would find on your own insurance, versus the actual cost value, which would include the depreciation, which is the sort of recovery that you're looking at when you're filing a third-party claim. Additionally, that ends up being a huge difference. Oftentimes, we see the offers being from third-party carriers roughly somewhere between 1% and 10% of what we end up recovering from a first-party carrier. Now, ultimately, that third-party carrier will be, quote unquote, on the hook if the first-party insurance decides to subrogate. But I would say the biggest difference is certainly in cooperation and in the way that the claims are paid.
All good information. And Bill, I'd like to leave on one last good note. I want you to tell our audience, how can they get in contact with Falcon Engineering Group if they're interested in some of that preventative inspections or upfront inspections that you talked about, as well as investigating any damage that's caused by a nearby construction site?
Sure. Yeah. Please just reach out. You can follow us. You can find us on the web at www.thefalcongroup.us, or you can call us right here in our Miami office at 305-663-1970. Feel free to ask for me, William Pyznar. I'm the principal of the firm, and I will either take care of it myself or direct you to the right people. Well,
huge thanks to you and Craig. I really appreciate you guys joining us today. Thank you for all of our attendees that have tuned in this week. We overcame some technical issues in the beginning, and I'm very grateful for the opportunity to chat with Bill and Craig about an issue that we're seeing a lot. And I think there's a lot of really good information that we provide today. But the best part is you can go online at getglobalpro.com. You can check out our website, click the resource section to read and download important information. You can follow us, check out our YouTube page, because this broadcast, as well as all the other broadcasts, are available there, where you can view, watch them, share them as much as you like us and follow us and engage us on all of our social media platforms. We love to connect with our clients and our community. So call us anytime, shoot us an email. We'd love to hear from you. We're here to help you. We want to be a resource to all community associations and businesses, whether it's placing insurance to recover from loss. Remember to tune in next week. We have a special guest joining us, Jill, who is the Chapter Executive Director for Southeast Florida Community Association Institute, will be joining us. And we're going to take a close look at trends and recent changes to the property management industry in South Florida in the wake of the pandemic and a very, very active storm season. While there hasn't been a storm to hit us here in South Florida with a direct hit, there's been some storms that have been in and around the area. This is incredibly active storm season, and our hearts and prayers go out to all those that have been impacted by Hurricane Zeta. It was almost a Category 3. A strong Category 2 is at 1 mile per hour, I believe, shy of being Category 3. So we're always in the front lines trying to do our part. This certainly won't be anything differently. That area has been just pounded by hurricanes, one after another. And I'm sure waking up today is no easier than it was yesterday. So anything all of you, our attendees and audience, can do to help, I encourage all of you to go online. The Red Cross does always an amazing job, and there's many other local charity organizations that we always reach out to and support as well. So again, huge thanks to Bill and Craig for joining us today, and all of our attendees for tuning in this week on the Recovery Report Live.